Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And as is the norm, we always have a number of important issues to discuss in a given program. I want to begin, as I would normally do, by welcoming our viewers who are joining us on television in Region 5. Welcome to another program of Issues in the News. To our viewers who are also joining us on television in Region 6, along the east bank of the Berbice River, New Amsterdam, Kanji, and further down the Quarantine Coast, all of you who are joining us on NTN television, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, and even further afield. Welcome to another program of Issues in the News. Again, I reiterate that we must share this program. Press that share button on your phone, press that share button on your computer or on your laptop or on your iPad or whatever device you're using. Share this program so that you, your friends, and your followers can join in tonight's discussion. We want the widest audience possible. So share the live, share the program so that the widest possible audience can join us tonight. And I invite you also to send me your questions, send me your comments, interact with the program, interact on the program by using the comments column of your Facebook account to send questions to me, to send observations to me, to send comments to me so that I can respond as far as possible, and also we can make the program as interesting and as interactive as possible. Diochan Hafiz, David Bhagwan, Ronald Joseph, Sean Agard, Robert Ramp, Ganga Prasad, so many of you, thank you very much for joining us, and let's begin tonight's program. I want to begin by extending Navratri greetings to all my Hindu brothers and sisters, firstly, and secondly, to all Guyanese. This is a holy period on the Hindu calendar where we pray to Mother Durga for 9 days and 9 nights. Normally there is fasting in accordance with Hindu rites, and a lot of prayers take place across the length and breadth of our country in the mandirs, and a lot of Durga Puja would be done by Hindus across this land and in the diaspora. Navratri greetings to all of you. I also want to take this opportunity to extend Eid greetings to all my Muslim brothers and sisters, and indeed to all Guyanese. Tomorrow we will be celebrating Eid across Guyana and perhaps across other parts of the world. I know some have already begun to celebrate Eid depending upon the sighting of the moon, but in Guyana, tomorrow will be our celebration of this great holy Islamic festival. So Eid Mubarak greetings to all of you, and that is the beauty of our country. We can celebrate Eid and we can celebrate Navratri at the same time, and we have no conflict. And that is the religious diversity, the cultural diversity, and the tolerance which exists in our country and which is guaranteed to us by our constitution, the supreme law of this land. So Venezuela has filed finally its counter memorial at the International Court of Justice in keeping with the April 8th, 2024 deadline. We welcome this move by Venezuela. At least there is some indication that Venezuela is showing respect, finally, for the process of the ICJ, and they are contesting the case. And we say that that is the place where the contest should take place. We say very emphatically that if there is a controversy, if Venezuela believes that there is a legal dispute, then the appropriate tribunal to adjudicate and settle that dispute finally and conclusively is the International Court of Justice. It would serve Venezuela's cause well if Venezuela decides that that should be the forum to conclusively bring this matter to a lawful end. President Maduro and the Venezuelan government taking extra legal steps and extrajudicial steps, especially in the face of those proceedings pending, are not only unlawful, but they are disrespectful to the process of that mighty institution, the International Court of Justice. Countries have an obligation to ensure that they pay adherence to international norms, international laws, and the jurisdiction and mandate of international institutions such as the United Nations and such as the International Court of Justice. If not, then the world will descend into a state of anarchy and lawlessness. Every country, every independent country has what is called sovereignty, and that sovereignty gives it a compendium of rights and freedoms not to subject itself to international processes. But if every country decides that they will take that posture and adopt that position, then international law, international peace, international order will collapse, because each will become a law unto themselves. And where would that take us as a collection of nations that would like to live in a world of peace, stability, law, and order? So the behavior of Venezuela thus far does not affect only Venezuela. It strikes at the heart of the international rule of law, global peace, and global stability. And that is why almost every organization in this hemisphere has taken a position that is opposed to the posture of Venezuela. The OAS, the Organization of American States, and the Caribbean Community, CARICOM, have once again condemned Venezuela's latest action of enacting laws in its parliament to annex Guyana in this condemn those actions in the strongest possible terms. Because while Guyana is directly affected, the entire CARICOM and Latin America region is under threat. When the rights of one free man is threatened, the rights of free men everywhere are threatened. So it's not only Guyana that is under threat, but it is the entire Western Hemisphere and perhaps beyond. The world is one integrated village, and what affects one country spills over and affects many others. If Venezuela refuses to respect the jurisdiction and the authority of institutions such as the International Court of Justice, the UN Security Council, and the United Nations itself, then Venezuela is striking at the heart of international law, global peace, and global stability. Because today it may be Venezuela, tomorrow it may be another country. And if it is to have a domino effect, then eventually we would be living in a world where the rule of law has no place and every country does what it wants to do. That is the very definition of anarchy. And that is the implications which flow from the actions of Venezuela. And that is what is also being condemned. Not only the direct attack on Guyana's sovereignty and Guyana's territorial integrity that is at stake here. It's the actions of Venezuela has much deeper and far-reaching ramifications and consequences. I hope, and no doubt many would hope, or many are hoping, that this signal by Venezuela of submitting its counter memorial to that of Guyana is a positive one, and it would lead to more actions that are compliant with international norms and international rule of law. As the President indicated, the United Nations Security Council is currently reviewing the latest position adopted by Venezuela. That is to say, the enactment of that repugnant and offensive legislation that purports to annex Essequibo to Venezuela. We are hoping that positive actions will arise from the UN Security Council's consideration of the matter. I have already indicated that that law and the actions taken by Venezuela in enacting that law violates the interim measures granted by the ICJ in December of last year. And it is the UN General Council it is the UN Security Council that has the mandate of ensuring compliance with orders issued by the International Court of Justice. So we anxiously await the outcome of that consideration. It is now common knowledge that our government, under the direction of His Excellency the President, has made a decision to move firmly and condignly against defaulting contractors who are executing contracts for and on behalf and with the government of Guyana. We have stated publicly that undue delay and fundamental breaches of the terms and conditions of those contracts will result in a series of consequences, including sanctions, the imposition of liquidated damages, termination of the contracts, and other measures. In furtherance of that decision and initiative of the government, and acting upon the instructions of His Excellency Dr. Mohammed Irfan Ali, on April the 6th, 2024, I issued a memorandum to all ministers of the government advising them to immediately make functional within their respective ministries and project units a unit to specifically and dedicatedly evaluate the execution of all contracts being undertaken in their respective sectors in order to assess the performance of the contractors in the discharge of their contractual duties and obligations. The memo further states that once unjustifiable delays, substandard works, and other such fundamental breaches of contract are observed, then clauses of the contracts dealing with notification of the contractors of the alleged breaches and remedial provisions dealing with sanctions such as liquidated damages, forfeiture of securities, and termination, etc., should be immediately invoked and activated. As part of this initiative, and to support the work of these proposed units, a contract compliance unit has been established at the Attorney General Chambers and Ministry of Legal Affairs. The functions of this unit will be to provide the relevant legal advice and appropriate guidance when requested, and also to act when necessary, including the filing of legal proceedings when it is considered just and expedient to do so. So, following that decision, there is now a mechanism that is established in all the ministries, and that mechanism, that unit, is to dedicatedly monitor and evaluate the performance of contractors who are executing contracts in those respective ministries. And once that unit observes unjustifiable delays and fundamental breaches of contracts, they are to activate and invoke the clauses that relate to notifying the contractors of the delay and the breach, the clauses imposing sanctions, including liquidated damages, the clauses dealing with securities, performance bonds, etc., and the clauses dealing with termination. And to support the work of these units, a unit is also established in the Office of the Attorney General that will lend support, legal guidance, and will also act when necessary, depending upon the reports we receive from the various units across the governmental structure and spectrum. And these actions obviously will include instituting legal proceedings. So contractors are cautioned to ensure that they discharge their functions diligently, that they execute their contracts expediently, and that they deliver the quality of work and service that the contract contemplates and requires. This is another demonstration of our government's commitment to move condignly against contractors who are negligent in the discharge of their contractual duties. So these units are now being established, and they should be up and running in a very short period of time. So I am looking at your comments, and I am prepared to answer and to respond, answer questions and respond to your comments as the program progresses. So over the weekend, many of you would have seen on my Facebook page an interview that I did with the Department of Public Information, in which I explained why the government has decided to approach the Caribbean Court of Justice after the Court of Appeal of Guyana ruled that the government should not be a party to a very important case involving the oil and gas sector. It's not my desire to rehash what I said on that program here, but to supplement what I said so that I continue to clarify the confusion that is being peddled out there, and I bring greater clarity to the issue. As usual, the Kaicho News is attempting to distort what I have said. Firstly, they have a headline here that says that I said that the government has no obligation to tell the nation that the government moved to the CCG. This is a blatant untruth. I never said that the government has no obligation to tell the people that we are moving to the CCG. I explained that the government has utilized the normal conventional methods as outlined by the relevant rules of court in filing an appeal against a decision that the government feels aggrieved by. We did nothing out of the ordinary than comply with the law. What I did say is that I have no obligation, neither does the government have an obligation, to provide Kaichor News, or any news outfit for that matter, with court papers that we file. We have no such obligation. And I repeat that. The government has no obligation to any press outfit or reporter to provide to that press outfit or that reporter court papers that the government files. I made it clear that the papers are not secret, that the press can get those papers as they have been doing for decades by approaching the appropriate authorities. These documents that are filed in the court are not private documents. They are public documents. And reporters over the past decades have easily been able to get copies of these documents. But I am not prepared to give a news agency papers that they will use and misuse, interpret and misinterpret, and then attack the government. And that is exactly what Kaichor News does. And that is what I said on the program. And I don't know which government or which person would give another person ammunition to shoot him or to shoot his government. Who would do a thing like that? Why would I load your gun knowing that once your gun is loaded, the only place you're pointing it at is at me? So whoever wants the proceedings, they can go and get it. And I maintain most resolutely and most emphatically that the government has a right to be heard in the proceedings, that the court was wrong to tell us that we are not an interested party, and we have a right to appeal a decision that we believe is wrong. If Vanda Radzik and Colin White and some Fredericks and all these people have a right to challenge the government and challenge and file challenges in the oil and gas sector, the government that is running this sector, the government that is a party to the contract under which this sector is operating, the government that granted the license for the operations, does not have a right to be heard in proceedings in relation to that sector? In what world is that acceptable, fair, just, or even commonsensical? At what level of rationality? And that is why I feel so strongly about the Court of Appeal's ruling. As I explained in that TV program, it has greater implication than the case itself. Because going forward, if we don't appeal that decision, then courts in the future will feel justified in shutting us out, and we will not be heard in important matters that affects the public interest and the government's interest. The government of the country is the protector of the public's interest. And once the public interest is affected by litigation, the government has a right to be heard. That is a universal principle of law, evolved out of fairness and natural justice. Kaicho News has another big headline. Is the government that must decide what protection Guyana must have from an oil spill, not the court, says AG. But that is the law. It is the government and the Environmental Protection Agency together who have that responsibility, not the court and not the press. And that is what the law says. Let me read the relevant provisions of the Environmental Protection Act so that you can follow the argument. Section 31 of the Act, well, it starts at Section 30. Section 30 of the Act defines what financial assurances means. Financial assurances, that is the term. That is what the unlimited guarantee, that's what it's called, a financial assurance. Is defined as cash in the amount specified in the environmental authorization, which is the environmental permit, if you wish. B, a letter of credit from a bank in the amount and terms specified in the environmental authorization. A bank or a letter of credit specifying the amount, you hear that? The amount and terms specified in the environmental authorization. I'll come back to that. A guarantee in the form, terms, and amount specified. Again, I pause. Amount specified in the environmental authorization from any person whose long-term unsecured obligations are rated equally with a bank by an international recognized credit rating agency. A performance bond in the form and terms specified in the environmental authorization. So that is what the financial assurance means. These things. Cash in an amount specified. A letter of credit in an amount specified. A guarantee in an amount specified. You see the emphasis on amount all the time? How can it be unlimited? This is the law I am reading. This is the Environmental Protection Act that requires this assurance. Every step of the definition, dealing with different instruments, whether the assurance comes in the form of cash, there is an amount that must be specified. If it is a letter of credit, there is an amount that must be specified. If it's a guarantee, there is an amount that must be specified. You can go and read it for yourselves. And I'm hoping that the press would go and read it. It's the Environmental Protection Act, Chapter 20:05, Section 30, that defines the financial assurance. But I'm not finished. Let's go on. Section 31 now. The agency, that's the Environmental Protection Agency, may include in any environmental authorization a requirement that the person to whom that environmental authorization is issued shall provide financial assurance to the state for any of the following. Let me read that slowly again. The environmental agency may include in the environmental authorization, which is the environmental license or permit, a requirement that the person to whom the environmental authorization is issued, in this case the oil companies, shall provide financial assurance to the state. Now, who is the state? Who is in charge of the state? Not the government of Guyana? So am I not correct to say that this financial assurance is to be provided to the state, to Guyana, to the government? The government will not have to play a role. Is it not the government that is involved? So I continue. The other important part of the law says this. A requirement under subsection 1, the requirement that I just read, the requirement of a financial assurance to the satisfaction of the state shall specify the amount of the financial assurance and may provide that the financial assurance be provided, reduced or released in stages specified in the environmental authorization. Let me read it slowly again. A requirement under subsection 1, that is, once the EPA requires the financial assurance, the EPA shall specify the amount of the financial assurance. How can a judge order an unlimited financial assurance? This is the law. This is what the judge has to interpret. As I said before, an unlimited financial assurance is an animal that is unknown to the law. And the definition, the very definition of it in the law, speaks to an amount. You can have it in cash. And it says the amount must be specified. You can have it in a letter of credit. It says the amount must be specified. And you can have it in the form of a guarantee, but the amount must be specified. In the face of this clear, cogent, and compelling language of limitation, how can you have unlimited assurance? And these operations can be shut down because of the imposition of a requirement that is legally and financially impossible. If this operation is shut down, the government developmental plan comes to an end or becomes severely affected. The people of Guyana who are expecting their lives to be transformed will become affected. All the things that you are asking for every day will not be able to be delivered. And the government of the country must not be heard in a case that can possibly have these dire, drastic, and catastrophic consequences. And when the government tries to get involved, the government is shut out. And when the government appeals, the government becomes the big bad wolf. And I want again to reject this narrative that the government is in bed with the oil companies and that we are acting in collusion with and in support of the oil companies. That is a complete and utter falsehood. We are acting in the best interest of Guyana, the sector, and the people of our country. Because if the sector shuts down, all will be affected except that privileged few who are working every day to shut the sector down. Up to now, I don't understand the reasons for taking the position that they are taking. I explained in that program this weekend that this assurance doesn't mean this is only an assurance. This is not the amount necessarily that the government or the country would be entitled to if there is some disaster. Not at all. This is simply a sum that is being lodged as an assurance. The law of negligence and the polluter pay principle say that the polluter must pay for all the damage he or she causes. The law of negligence say that he who commits the negligent act must compensate for all the damages caused by or occasioned by the negligent act. If it is 100 billion US, then that is what we are entitled to. It is not limited in any form or fashion by this assurance. That is the kind of misconception and misunderstanding that is being pushed in certain quarters of the press. And when the government seeks to clarify it, when the government seeks to dispel this deluge of misinformation, the government is accused of being in bed with the oil companies. So we must say nothing and allow this misinformation, this propaganda, this baseless narrative to permeate and perpetuate. And we must stay silent, because if we dare say anything, it is misinterpreted and then misconveyed as defending the oil company. That is not freedom of press. That is an abuse of freedom of the press. What Kaijo News has done to what I said on the program is an abuse of press freedom, not an exercise of press freedom. Press freedom doesn't entitle or authorizes misinformation and peddling half-truths and innuendos. And that is what passes for free press. And tomorrow again, I may get another headline. No doubt tomorrow, after they hear this program, rather than report accurately on what I'm saying and go to the law and read it themselves so that they can accurately put out a story so that you, the people out there, can be better informed, they are not going to do that. They're going to continue to peddle the jaundiced version that they are so accustomed to peddling. And let me make one point before I move on. Two points I want to make before I move on. One is that the very contract, the 2016 contract, which we have said, and let me repeat it for the record of this program, is an unfair contract. In fact, the words that I've been using since 2017 is a lopsided contract. That very contract, Mr. Nandlall instituted proceedings to challenge. And many of the arguments that he's peddling in his newspapers, he took to the court. He had many lawyers representing him. Many of them are also commentators, or one of them at least, is a prominent commentator in another press, another newspaper. And a group of lawyers, they moved to the court to challenge the contract. They had the opportunity to tell the court about all the bad things about the contract. And they did. And what happened? The judge rejected their case. The judge said in law, they did not make out a case. They argued that the contract is illegal, that the contract is in contravention of the laws of Guyana, that the license is illegal, that the license is in contravention of the laws of Guyana, that it is in contravention of the Constitution. All of that they went to the court and they argued. And in February 2023, the case was dismissed. It was filed in the name of Nandlall, and it was dismissed. And you know what? Mr. Nandlall never appealed. He never appealed. If he feels so strongly about this contract, and he felt that he had a good case, why did he not appeal? These are the questions. First of all, I don't think he says, or he has said recently, that he filed a case and that he went to court and he argued. Of course, the case was prominently reported in the paper, in his papers when it was going on. But when he lost the case, we never heard back about the case. But he should say that he went to court and the court told him that they can't do anything about the case, about the contract. Or at least he never made out a case for them to set aside the contract or to quash the license. And when he lost the case, he never appealed. Yet he expects the government to do magic and make the contract disappear. So, my friend, again, I am taking a lot of time because this is an important issue. And there is so much misinformation, And this, I warned about this already. This tendency which continues to preponderate, that is to say, the creation and peddling of a fabricated narrative that the government is in bed with the oil companies is one that is unpatriotic and anti-national. I cautioned that when we were in St. Vincent, at Argyle Airport, in the meeting with President Maduro had volumes of these very articles And he was referring to them repeatedly in support of his contention that Guyana is selling out to the Americans and selling out to the oil companies, and that the government is selling out, and that he has articles from Guyanese newspapers that say that, not Venezuelan newspapers, Guyanese newspapers. That is the point that he was making. He was throwing that in our faces to say, look, your own people are saying that you are selling out, not Venezuelans. And we intend to take what is ours before you sell it out. That was the thinking, and that was the thrust of the argument of President Maduro. So every time these narratives appear, as fabricated as they are being compiled by our enemies to be used against us. And when we came back from St. Vincent in December of last year, I made it public. Some people misunderstood me. Some people attacked me. They accused me of wanting to stifle freedom of expression. And I said, I am not doing any such thing. I am just adverting your attention to the fact that when you make these irresponsible and on many occasions baseless contentions and allegations in the press, there is a grouping out there who wants to invade our country, and they are building a case to do so. And they are using this kind of materials that you are peddling. Don't I have a duty to say that as a citizen, and moreover as Attorney General of this country? I think I do. Forget Attorney General, I have a duty as a citizen to say so. And I have said so. And I am reiterating it here because it has not stopped. Again, you will hear about I am trying to stifle freedom of expression. 3 land court judges were sworn in last week, and I welcome those appointments, and I wish to congratulate. And let me correct it quickly. It's not land court judges. We have been using this term loosely, and as Attorney General, I should correct the mistake for the public record. They are commissioners of title. They are loosely called land court judges. I repeat, they are commissioners of title. I wish to offer my congratulations to the recent appointees, Esther Sam, Ranita Singh, and Christelle Lambert. The Barbicians would be pleased to know that 2 of the 3 commissioners of title will be assigned to the county of Berbice. I know on this program you have made innumerable comments and complaints about the absence of a commissioner of title in Berbice for almost 7 years. Well, these long-awaited appointments have been made. I know that there would have accumulated a large backlog of cases in the system in Berbice, and it is hoped that with the new appointees, 2 of whom are to be assigned to Berbice, this accumulated backlog of cases will be aggressively tackled. We are quickly coming to the end of the program. I don't want to deal with another issue at this point in time because I may not be able to complete it. But Sandy Ramatar is asking me a question. Sandy Ramatar from MTV News Update, whether the monies awarded as costs from the numerous unsuccessful cases filed by the opposition have been paid. I am to report, and I believe I did report on previous occasions, that they have paid after I wrote several letters threatening to take enforcement actions against them in accordance with law. So they have paid off all the outstanding sums as costs that were owing. A question is also asked of me to provide a status update on Guyana's law school. As I said, the stage where we are at is to prepare a feasibility study to show how the law school would be viable in Guyana. It is a protracted exercise, a time-consuming one, because a lot of information has to be amassed for presentation to the Council of Legal Education. I believe that we are nearing completion of that feasibility study. After that, that document, once approved by the government, will then be presented to the Council of Legal Education. My operator is signaling to me that we have come to the end of the program. I want to thank you very much for spending the past hour or so with me. I believe that we have covered a number of important issues. I want to reiterate my Navratri greetings to all my Hindu brothers and sisters, and indeed to all of you, and also to extend once again Eid Mubarak greetings, especially to my Muslim brothers and sisters, and indeed to all Guyanese and people everywhere. Thank you very much, and take care until I see you next Tuesday.